We'll get going in just a moment, everyone. I'm going fast today. There's a lot to get through. Richard, would you mind grabbing that door? Okay, it's about 1 minute to noon, so we are going to get started. We've got a lot to cover today. So hello, everyone, again. Welcome to our latest installment of the Lunch and Learn program. Today we have our very own Hillarie Tasche here to give us an overview of the Supreme Court of Canada year in review. To give you a little bit of background about Hillarie, she was a graduate of the University of Saskatchewan, Faculty of Law. She was the class of 2008. Hillarie articled with Legal Aid and was called to the bar in Manitoba in 2009. 17 years later, she remains on with Legal Aid Manitoba, and as she puts it, is likely a lifer. Hillarie began her career in a mixed practice handling family matters, child protection, administrative law, as well as criminal matters. In 2011, Hillarie transitioned to the youth criminal justice-based practice, where she's now the assistant supervising attorney at our Regency Community Law Center. In the fall of 2021, Hillarie entered her master's program at the University of Manitoba at Robson Hall. While there, she pole vaulted with the Bison track and field team and lived to tell the story. Hillarie's had a very interesting life. Andrew, I'm just going to mute you here.
Sorry about that.
Yeah, if you could just mute yourself, please. So Hillarie's master's thesis explored the Youth Criminal Justice Act adult sentencing provisions, and the timing of her finishing it, that publication was really good in January of 2024, because within 2 weeks, her thesis, the final draft of it, went off to the Supreme Court of Canada and was part of the Book of Authorities for a case where two young people, the RVIM and the RVSB cases, which she will touch on, were happening right at that time. So Hillarie was consulted with both defense teams in that matter and many of the intervening parties as well. And she had the opportunity to travel to Ottawa and watch the Supreme Court of Canada hearing with respect to those matters. Hillarie has presented at provincial, national, and international conferences on topics related to youth criminal justice. And she's excited to share with you right now the 2025 Supreme Court of Canada year in review. And I will just add that Hillarie is one of our youth experts here within Legal Aid Manitoba. So go forward if anybody has any questions regarding youth matters. You can feel free to reach out really to anyone in our youth office. But Hillarie herself is one of the experts in that regard. So I'm going to pass it on to Hillarie, and do you want me to start sharing your screen?
Yeah, might as well.
And so just give me a moment here. I'm just going to share her presentation and make sure that you can all see it. And that's the one, right? Yes. And it's not at the beginning, actually. Just 1 second here. To give me 1 sec, I'm just going to say if I say slideshow, start from the first slide. Perfect. Yeah, can you guys see the Supreme Court of Canada?
I took that picture.
You can see that, Gary?
I sure can.
Okay, great. So if everyone can mute yourselves, please. And with that, I will pass it on to Hillarie.
Thanks, guys. Okay, so I probably did something that was a little overly ambitious, so I'm going to have to speak really quickly in order to get through everything today. We are doing a Supreme Court of Canada 2025 year in review for the criminal law cases in particular, with a bonus of the 2026 cases to date. So I've grouped them essentially in some categories, but first I just wanted to give you guys a rundown of all of the criminal cases that were heard in 2025 and 2026. The highlighted ones, the ones that are in bold, are the ones that we're going to touch on today. So you'll see, and when we look at the entire list of Supreme Court of Canada cases, it becomes very apparent that criminal law really does take up a lot of their time. They do a lot of work in criminal law. And so 2025, this is the first half of 2025, second half of 2025. So quite a number of cases. And then we have these about 7 of them now that have been heard as of April 17th. We're going to touch on 3 of those today. Okay, so We've only got about an hour together. We'll see how we do here. First, I want to talk about some cases that deal with voir dires, when to hold voir dires, what to be looking at. I'm going to see if I can move this. Sorry, I just got to move this off a little bit of my.
Might want to just do the one to the left of it and it'll just,
This guy,
no, yeah,
this one, hide thumbnail video. Yeah, I can hide the thumbnail video. I'm okay with that. There we go. Thanks, guys. So Kinnamore is the first one that we're going to deal with. It has to do with a case whether or not where social media messages between the accused and the complainant in a sexual assault trial were admissible, where the complainant's sexual history was discussed. And in that case, the talk that was going on in the social media messages was particularly about the fact that she was a virgin and about the fact that she was not interested in the accused in a sexual manner. The Crown sought to, advance this evidence and did so without a voir dire, thinking that it didn't fall within the rules, that generally speaking, fall on defense's shoulders to have those matters admitted. I'm just getting some feedback. I'm just going to remind everyone to mute themselves. I don't know who I've got, but someone's. I'm just gonna have everybody mute. Good. Okay. So back to it, we've got a case where really the Crown ought to have been held to the same standard for the admissibility of those messages, because they were presumptively inadmissible because they did discuss prior sexual history. So the Supreme Court clarified the rules for the Crown, and that voir dires apply to both parties. And the SEC allowed the appeal. They quashed the conviction. They ordered a new trial, holding that the trial judge erred because they said there should not be a voir dire. They failed to hold a voir dire to determine the admissibility of the messages. They really just handled the issue kind of on the fly, it seems like just letting them go in. So good reminder that when there's evidence that might serve the Crown's purposes that could relate to prior sexual history, they too are bound by those voir dire rules. Okay, moving on. Another case about voir dires is Carignan from 2025. The Supreme Court in this case looked at the lawfulness of an arrest. Carignan was essentially named as a suspect in a sexual assault matter, brought in for questioning and arrested without a warrant. So they looked at section 495(1) of the Criminal Code, which describes cases where an officer can arrest someone without a warrant. 495(2) sets out the conditions that limit that power, including on the basis of public interest and that there's a risk the person arrested will not attend court. So there's limits on when you can arrest someone without a warrant. The trial judge refused to hold a voir dire on the lawfulness of the arrest and just sort of summarily dismissed the motion around the warrantless arrest. Then the Supreme Court finds that the text of 495(2) in the Criminal Code imposes limits on police and their power of arrest. So, and it's a mandatory in nature, so it can't be just fluffed off without a voir dire. So they gave some interpretation there, and they held that the judge's refusal to hold a voir dire on the lawfulness of the arrest was an error in law. So that's something good to keep in mind. Okay, next off, the Supreme Court had a big year for standard of proof cases. So we're going to first talk about IM and SB, which are youth cases relating to adult sentence applications and where there was a big change in the standard of proof. Then we're going to talk about a case called DePaula, which is standard of proof for aggravating factors on sentencing. And then we're going to talk about the John Howard Society case out of Saskatchewan, which is actually a prison law case, which also raises the standard of proof required for administrative law tribunals like the John Howard Society, like the prison law regulations. So let's start with IM and SB. These were cases that I helped on for the two defendants who were bringing the appeals, IM and SB, as well as many of the interveners that were involved. The Youth Criminal Justice Act sets out that the test for an adult sentence application that the Crown brings is a two-part test. and that both of those prongs must be independently satisfied by the court. Up until now, that word that I just used, satisfied, was the standard of proof, which was really difficult to deal with because it's not really defined anywhere and is a very wishy-washy way of looking at things. And the previous case, R versus OA out of Ontario in 2007 or something like that, 6, sort of just said the judge had to kind of be a little more than balance of probabilities, a little less than beyond a reasonable doubt, which was really proving to be unworkable. And you'd get a huge disparity of results in how that standard of proof was applied, and you'd get that problem all across Canada. I focused in my research on prong 1 when we look at sort of the personal circumstances of a young person who's facing an adult sentence application. But the case in the Supreme Court went even further. The litigants for IM and SB brought up this nebulous status of satisfy. The Saskatchewan Provincial Court had already talked about how the fact that this is an unworkable standard and had really strongly suggested for years now. Justice Anand had said that this should really be a beyond a reasonable doubt standard. So the matter goes up before the Supreme Court, and a big issue that they look at there is what do we need to do with this? A judge must be satisfied on these standards. So for the first prong, which is, the Crown has to prove, the Crown has to rebut a statutory presumption of diminished moral blameworthiness of young people. All young people are presumed to have a lesser capacity than adults, and the Crown must rebut it. And now the standard of proof for that rebuttal on the first prong is beyond a reasonable doubt. So that was the major update on youth law. This was a groundbreaking case, and it really will change the landscape for these cases going forward. The second prong is more in line with, they don't go so far as to say that the second prong is beyond a reasonable doubt, because essentially it is a proportionality test that we see in other areas of sentencing, and judges are able to do that based on the language in the second prong. So in IM in particular, this young person did have their adult sentence application overturned, or their adult sentence, overturned, and was therefore then sentenced as a young person. I'm not sure if he was actually freed, because I think that at the time he was pending on institutional crimes of violence. So I'm not sure if IM is actually free, but he was successful in his appeal, and he was successful in turning over the adult sentence. And the court was able to give this really helpful commentary and new law for us. And then SB was the companion case. And unfortunately, this young person was not successful, but they did apply the case. They did apply the new law, saying that the new standard of proof being beyond a reasonable doubt. But as they applied that new test to SB, they said, even with this, regardless of the standard of proof, this young person, the Crown has rebutted the presumption of moral blameworthiness, and a longer sentence than what is available under the YCGA was appropriate in the case. So that's those two cases. I could talk a lot more about them, but I won't, because I spent 3 years on it and I have a lot of trauma, and I don't even like to look at them anymore because they just look like work to me. Okay, next one. Oh, and there's me there. That's some pictures. So there's Ottawa. I am a giant nerd, so I made a mini version of my thesis to bring with me for fun as a little traveling gnome. And so there you go. That's proof that I went there. I didn't have to argue, and I was so happy for that. I didn't have to stand up and say anything. The paper got to speak for itself, and the litigants that brought the case out of Ontario and all of the interveners did a far better job than I ever could have. So I was so happy that I just got to sit and watch. Okay, standard of proof once again. This one is R versus DePaula. In this one, DePaula had some previous financial crimes. And he had made a plea deal essentially for some previous sets of charges where he got the most serious charges withdrawn and pled to a lesser offense. So in some previous dealings with the court, he has a and again, let's make sure we're muted.
Kevin, mute.
Firms instead of.
Hey, Kev, throw on your mute.
How does that work out?
Say again.
Throw on your mute.
Then he wants to report to the.
Hold on.
franchise.
And it's gonna be like solicitor client privilege stuff. Just wait, muting Kevin. Okay,
There you go.
there we go. Okay.
We do it all the time in our office.
I don't know how these mutes get unmuted so quick. Okay, going back. All right, De Paula, white collar criminal. He makes an arrangement, gets his most serious charge thrown out, pleads to a lesser offense. Later on, gets charged with some similar sort of dealings. I think there's some fraud going on. I can't remember exactly, but he gets in trouble again, and the Crown wants to use the facts related to the withdrawn case as aggravating facts on sentencing for these new ones. And so the Supreme Court of Canada declares that a judge can consider facts related to a withdrawn charge if those facts are related to the offense and if the Crown acts fairly by giving really robust notice about the fact that they're going to be bringing up these previous charges that had been withdrawn. So yeah, like I said, in these previous matters, De Paula made an agreement. The most serious charge was out. In the current proceedings, they want to relay it. The Supreme Court says that 725(1)(c) authorizes a judge to consider any facts forming part of the circumstances of the offense, even if those facts could give rise to a separate charge that was laid and then withdrawn. This rule gives judges a full picture of the offender's conduct and allows the judge to impose a fit and appropriate sentence. But they did also hold that the Crown must act fairly when they do this by giving a lot of notice. So for me, what this says to me as far as why I put it in the standard of proof category was that all aggravating factors have to be proven beyond a reasonable doubt. So if that charge initially was withdrawn because it couldn't have been proved, you could certainly have if the Crown wants to rely on those aggravating factors at a later sentencing, you could essentially have a
Gardner hearing.
Yeah, a Gardner hearing on the withdraw. You'd have a Gardner try just for it to be relied on as an aggravating factor. So that's why I put it in the standard of proof section in this one, because it could definitely form part of a very interesting Gardner hearing where the whole trial from the previous case could be heard just to get an aggravating factor on sentence. So that I thought was pretty interesting. Next one we're going to talk about is the John Howard Society, Saskatchewan versus the Sask AG. This isn't a criminal case per se, but it definitely affects, our client in criminal law. So I wanted to include it. It's a prison law case, administrative law. So inmates charged with disciplinary offenses in Saskatchewan, they must appear before a disciplinary panel to answer to those charges under Section 68 of their regulations. So until this case, the standard of proof for such proceedings was a balance of probabilities. And now the Supreme Court has held that the standard of proof is guilt beyond a reasonable doubt, and that this applies to now this applies to inmate disciplinary hearings. The SEC said that the presumption of innocence also applies to disciplinary hearings. They held that the section, the impugned section in Saskatchewan's case, but arguably if there's like sections across other provinces, the same challenge could be easily made. They held that it violated both Section 7 and 11D of the Charter because it permits the imposition of imprisonment when reasonable doubt to the accused guilt may exist. So the penalty section for this Section 68 was, I think, you would lose 15 days remitted time, earned time, like early leave time, or you could get 10 days in segregation. So there is the imposition of further imprisonment within the prison obviously triggers those charter sections, and then taking away earned time would also trigger the imposition of imprisonment. So I think this is very much the proper decision to be made, and it overrules a previous decision in Shubley, R versus Shubley in 1990 Supreme Court case, where the Supreme Court at that time said that 11D was not an available argument. So we're making progress for prisoner rights and the rights of the accused when it comes to standard of proof on all of this case and on the preceding cases that we've talked about, and really holding most areas of criminal law to that beyond a reasonable doubt standard. Looking back at youth cases, the standard of proof moving to beyond a reasonable doubt mimicked the Supreme Court decision in the dangerous offender applications, which I believe the Supreme Court decided in the late 90s. It also at one point had to satisfy, the court just needed to be satisfied that a person would move up to be a dangerous offender. That was abolished in the 90s. And when the litigants were at the Supreme Court for the youth cases, they used the exact same mechanism and really drew a parallel between the jeopardy faced with a dangerous offender and the jeopardy faced by a youth facing an adult sentence. So really it was a very interesting year for accused rights and standard of proof when it comes to holding the courts to findings of beyond reasonable doubt.
Hillarie, sorry to interrupt you while you're on this point, but just for those who are listening, the CDLA has just announced they're doing a lunch seminar on prison discipline law on May 15th.
Perfect.
So if you're interested in this, and I think it would be a good one, read this case and then go to see the CDLA on May 15th and get.
To me, this one really warranted a deep dive. And so a person could really look at just this case alone and apply it to a lot of the prison law stuff that our students do and that we help our students with regularly and that our clients deal with all the time. It's not an area that I have a lot of expertise in. So this was certainly a really good read. And then May 15th, thank you for the plug on that. Yeah. So yeah, good year for standard of proof. It was also, you know what, it was a mixed bag for vulnerable accused, I would say. So I picked out 3 cases where I thought what the common thread between these 3 cases were, we're dealing with vulnerable accused people. So the first case is R versus JW that I want to talk about. And this one to me, I didn't think was all that great for vulnerable people. In JW, the Supreme Court confirmed that sentencing judges can essentially make a sentence longer just because they feel that that length will be required for making sure the person gets the treatment that they need. This is a concept that's really, at the core of youth law. We talk about this a lot in the adult sentence application context because part of the second prong of whether or not a person should get an adult sentence is whether or not the time that's allowed under the YCJA is enough to promote rehabilitation in the long term. And so this whole idea that, we can give longer sentences to someone who is, suffering with a cognitive disability just because they need longer time to sort of quote unquote get it or learn from the rehabilitation program, to me felt a little bit sad. But the Supreme Court says that in adult world, Supreme Court confirms that a judge can consider the time needed for treatment in determining the length of sentence and imposed quite a lengthy, in my view, sentence on JW because of the time that they thought that would be required for him to sort of catch on to what he was being taught in custody. The other thing that to me was wasn't as bad. This was rightly decided. I don't think it's very overly generous or anything. I just think it's the right decision, is that JW's case took a very, very long time to get to court. And the Crown, as a result, wanted to strip him of any enhanced credit. He went through 3 different lawyers and really he withdrew from 3 different plea agreements, even though they weren't entered. It wasn't like withdrawing guilty pleas. He did delay some of his hearings just through some of his conduct. But when they looked at it, they saw that this was all a consequence of his cognitive disability as well as his mental health. And so the Supreme Court ruled that refusing to give him enhanced credit really wasn't the right path, that his actions in delaying the proceedings were a consequence of his mental health and did not amount to wrongful conduct that would potentially justify denying an enhanced credit. So that one is okay. I don't know if I like that one, but either way. Barwani was next. This one dealt with a fitness issue. And to me, this one's in here because it's kind of like, I believe it was a dissent appeal that got him here. I was on the fence about adding this one, but I did because I felt that the court gave a very good definition of what it is to be fit to stand trial. So I've included sort of that in the longer paragraph below. So he brings first off, he's convicted of murder. He's found fit to stand trial at his trial. And then he wants to bring new evidence to the Court of Appeal later on to say that he wasn't fit at the time of trial. And ultimately, they all find that the original decision about fitness should be given deference, but the Supreme Court does give us a good definition of fitness. So they indicated that an accused is fit to stand trial when they're able to make and communicate decisions that are based in reality in the conduct of their defense, or when instructing counsel to do so. This necessitates an understanding of the nature or object and potential consequences of the proceedings that is grounded in reality, as well as an ability to understand and select between available options and their consequences when making decisions. It is not required that an accused be able to make decisions in their best interest, but they cannot be overwhelmed by delusions, hallucinations, or other symptoms of mental disorder when they're making or communicating those decisions. So from a practical perspective, I think for defense counsel, this is a good paragraph to keep in mind, that fitness is one of those assessments that doesn't always go as far as we think it does. And so if your client's making decisions, but not necessarily good decisions, that doesn't make them unfit. It's a more nuanced analysis. So that's the first two cases.
Actually, if I may,
Sure. Yes, you're the expert on this.
I said that case when it came out to the review board and also to some of the psychiatrists. I know they've had seminars on this point before. The good thing in there, I advise all counsel to read it, is the ability to communicate with your client. If your client is unable to communicate with you, you may have grounds for a fitness. And when you go for a fitness, ask the psychiatrist to apply this test and not the older Taylor test. There are still some psychiatrists using the older one, which is basically judge, lawyer, guilty, not guilty, and that's where they leave it at fitness. This one, they have to understand more about the concepts involved and, of course, be able to communicate. And I'm trying to use this one now for a fellow who may be mentally fine, but may have physical challenges to communicate with the court. So we'll see how that goes.
Yeah, and Greg makes a really good point, because the test previous really just felt like do you know who the actors in the courtroom are? And it's one thing to know who the actors in the courtroom are, but it's another thing to appreciate, what are my choices? And this clarification to me, I don't know a lot of the history of like the progression of the law, but when I read this, I was like, well, this makes the most sense of anything that I've heard in my limited experience with fitness. Prior to this, I'd always felt that it was just like, what does your lawyer do? What does the Crown do? What does the judge do? All right, buckle up, go into court. So Taylor was the case previously.
Right.
Okay. Again, another case that really warrants a deep dive. But we're rolling here because we got a lot to get through. Thank you, Greg, for that history. Next up, I'm looking at, I think that's all we have. Oh, no, we had one more. Wilson. Yeah, here we go. Wilson. I put this in the vulnerable accused category as well. This is a Good Samaritan case. So being a youth lawyer, I don't do a lot of drug cases. We just don't have a lot of drug cases, CDSA cases. So again, this is one where probably the CDSA folks the folks who do more CDSA will really benefit from this case, because they're very, very clear that Good Samaritan, if you call the police or if you call for help, if you call 911 to get help for a person who's overdosing, there is some immunity for charges later on. So in this case, Mr. Wilson, he stayed at the scene of an overdose after emergency services arrived. Police arrest him for possession of drugs, and during a search, they found evidence of other offenses, including firearms and identity-related crimes. He argues this is unlawful because those Good Samaritan laws were codified in CDSA 4.1 sub 2, and this gives him immunity not only from being charged with or convicted of an offense of possession, but also from an arrest for possession. And that's really where everything else flowed from. So he said the arrest and search violated his rights under Section 8 and 9 of the Charter, which protect him against search and seizure and being detained without a valid legal reason. Trial judge rejects this, which to me is wild. Trial judge rejects this and convicts, which is, I don't know how you make that error. Court of Appeal disagrees, ruling that Parliament intended the Good Samaritan protections to include immunity from arrest, and they set aside the convictions. And then the Crown appealed to the Supreme Court of Canada. The Supreme Court dismisses the appeal, so the Court of Appeal case from the lower court stands. So I think that was a very good decision. Surprisingly not unanimous. It was a 6-3 decision at the Supreme Court. Next, we're going to talk about some trial and appellate procedures. So some of these are interesting in their own right, but I've sort of tagged them as procedural cases, but they certainly have other points that if you read the cases in full, you might be able to find some nuggets. I've just been very limited with the amount of time I can take. So I'm going to start with Danawa. Danawa is a case on appeal from the Court of Appeal in Ontario. And the Supreme Court confirms that the man who was acquitted of various firearms offenses in error. So ultimately, I thought that this was notable for its path to the Supreme Court of Canada. Because I'm a youth lawyer, I really don't pay attention to a lot of the leave to appeal rules because we don't have them. If a youth has a dissent at the Court of Appeal, they don't get to go to the Supreme Court. It's codified. It's been heard by the Supreme Court of Canada that they're not going to give youths that right to appeal. Youths always have to have leave from the Supreme Court to have their case heard. So in my career, I haven't paid a lot of attention to the paths to the Supreme Court of Canada. But this is one where maybe other people know this. I didn't know this. Where a person is acquitted at trial, but the acquittal is set aside by the Court of Appeal, even if it's unanimous, if they enter a guilty plea, the person has a right to appeal the Supreme Court of Canada on any question of law. So I didn't know about that path to the Supreme Court, and I wanted to include that just in case anyone else missed that day in law school. So that's Danawa. Oh, also Danawa, interesting. The firearms expert was absolutely out to lunch. I thought, I'm pretty sure this was the one. Yeah. Danawa ultimately does not get back to the state of acquittal. He is definitely convicted. The firearm expert was like, oh, because the magazine wasn't nearby, it's not a firearm. It doesn't meet the definition of a firearm. Because you would need expertise. And you'd have to have this extensive knowledge in order to put it anyway. So it was a bad acquittal to start with, but I liked it for the path. Next up is Nguyen. This is a 2026 case. In this one, it's about forfeiture. So the Supreme Court of Canada says that even when criminal charges are stayed, after the fact, courts may still decide what happens to the property seized during a criminal investigation. So a stay of proceeding ends the prosecution, but it does not prevent the court from deciding what happens to property linked to the alleged crime. These are separate questions. You have to look at what sort of rule you're dealing with for forfeiture, because there's different sort of paths to have to forfeit items. Some forfeiture rules only apply if a person is found guilty or is sentenced. But because a stay stops the case before any finding of guilt, those rules cannot be used by the Crown in this case. However, there are other rules that focus on the property itself and allow courts to decide what should happen to it, even when someone found not guilty. So keep that in mind if Crown wants your client to forfeit items after the stay of proceedings has been entered. Bouvette. This one was interesting. So this is sort of like a kumbaya moment at the Supreme Court of Canada, because everyone goes there saying that this woman should have an acquittal entered. So it's a case, so this woman is found guilty of criminal negligence causing death, and a lot of the evidence that is heard in the original trial later on is debunked. It's either bad science. I'm trying to remember if it's bad science. Anyway, the expert is discredited all these years later, and everyone now is in agreement that there should be an acquittal because of a miscarriage of justice. Now, why did I find this procedurally interesting? Because the British Columbia Court of Appeal overturned the conviction, but they declined to enter an acquittal outright. And so they were going to send it back to trial. And it concluded that it did so because it concluded that there was evidence on record upon which a reasonable jury could convict Ms. Bouvette and no sufficiently exceptional circumstances to justify an acquittal. But there was, because the Crown themselves were saying, if this goes back to trial, we would not call any evidence. We would not prosecute her. So we need an acquittal in order to have this sort of cleared from her cleared from her sort of background. So they do enter a stay of proceedings. Ms. Bouvette, though, wants more than that. So Bouvette applies to the Supreme Court of Canada seeking an acquittal, and the Crown agreed she should have an acquittal. And the Supreme Court held, yes, she should have an acquittal. And this is because the Crown expressly said that they would not be calling any evidence at a new trial. So to be expeditious, everyone agrees this should be an acquittal. So I didn't know a lot about that procedural steps. So I was very happy to see this and interested, because you're always still learning. And this was something that I found very interesting. And Miss Bouvette is now free. How are we doing for time? Oh, we're actually doing much better than I thought, guys. So that's Bouvette, like so much better than I thought. I'm sorry, maybe I talked too fast, guys. Next one is Fox. Have you guys heard about this case? Has anyone, we've got 3 people in here. This is,
Yeah,
you've heard about this?
that was part of law school year 2.
Yeah. So this is a very interesting case, and I
Privileged to save your butt.
you know, it's one where we really have to be thinking all the way through our days about, the boundaries that we set and the way that we practice and what our ethics are. And I think Fox gets very lucky in this case, because let's dive into it. So Fox is a lawyer. Fox is a lawyer, and Fox is talking to their client. And so the Fox is talking to his client, and this client has a wiretap. So in the wiretap, they're supposed to identify, like, is this a solicitor client call? If so, we're not supposed to listen. So they're given some leeway in order for them to determine whether or not this is a lawyer call. And after they determine that it's a lawyer call, they're supposed to mute it and not listen. They keep listening. And that's really where the freaking saving grace for Fox comes in, because that forms a big part of the decision later on. So ultimately, Supreme Court of Canada here's this case. They hear of Fox on the phone call. The first half of the phone call, the courts had determined earlier on that this was not a privileged part of the phone call, and it was not protected by solicitor-client privilege. The phone call essentially contains discussion between the lawyer and the client, where the lawyer is warning her client about possible police searches and essentially advises the client to remove or destroy evidence. So at trial, there's this whole issue of, like, what can be disclosed to the lawyer to defend herself, right? So the Supreme Court ultimately rules that there is an exception to solicitor-client privilege to allow a lawyer to fully defend themselves against their own criminal charges. Generally speaking, solicitor-client privilege is meant to benefit the client, and so only the client may waive that privilege, but there is an exception for when you need that to defend yourself in court. Innocence at stake, exactly. Innocence at stake exception. So it allows courts to give an accused person access to the client's privileged communications to allow them to defend themselves. So from what I understand, it was a pretty big fight for her to get access to this phone call itself. She herself may have had some vague recollections of what was said, but she wasn't actually able to hear the call for quite some time.
Would it be applicable to law society proceedings? Your client, former client, accuses you of being a incompetent lawyer, for example.
I think the argument could be made.
So, yeah.
I think so.
But who records their phone calls anyway? So you don't have to be.
And I think we have rules about recording phone calls with clients. So we're a 2-party province. You can 2-party record, but you cannot record other lawyers without permission, and you cannot record your clients without their permission. But if you do have a clause with your clients to say, at the beginning of your phone calls to say, hey, for all of our, benefits, I'm going to record the phone call just to make things easier down the line and so that everything is accurate. If you had that permission, why not?
I wonder if you can ask your client if they're wearing a wire.
So yeah, your client is allowed to record you, is my understanding.
There's tech now that looks like a phone.
Yeah.
And you just push a button and it records everything and it sends you a transcript.
AirPods can be left in a room and cell phone can be out of the room. You can continue to listen and record if an AirPod is left in the room. So interesting, but yeah, Fox gets lucky, I think, because so Fox is charged with obstruction of justice. To me, if what was said was true, that she's warning someone of an upcoming search, I think that is very, very dangerous for a lawyer and potential obstruction of justice. But the Supreme Court throws out the whole thing because they don't stop listening. Bye, Greg. They don't stop listening when they realize that the second half of the call is now solicitor-client privilege. So Fox, I think, gets lucky in that the entire phone call, all of the evidence is thrown out because the police don't stop listening. And the Supreme Court reminds us of how important it is to protect solicitor-client privilege. If lawyers aren't allowed to talk on the phone with their clients confidently, it really, really undermines our system. And so even though Fox probably went too far on a portion of this call, they weighed this against the very important protections for solicitor-client privilege. And because the officers kept listening throughout that evidence. So Fox, I think, got lucky. If they had stopped listening, I think it would have been a different outcome. If they had only listened to the portion that wasn't solicitor-client, that would have been problematic for Fox. So that one was decided just quite recently in February. And then just last week, we have another case dealing with the role. Well, I felt it could go in the role of the defense counsel quite easily. The Madani case, R versus Madani. And this is a case out of Ontario Court of Appeal. The man is convicted of second-degree murder, and the Supreme Court of Canada upholds that conviction. Essentially, what goes on is there's a shootout at the Ottawa's Byward Market, and the accused fired 5 shots at another man, and the other man also fires one back and hits the accused in the leg. It was all captured on CCTV, and at trial, the accused said that he acted in self-defense. The jury does not accept this and finds him guilty of second-degree murder. 4 years after the shooting, the accused tried to introduce new evidence from a witness who he says would have substantiated the fact that the deceased had been the aggressor in the altercation, as well as evidence from the defense lawyer's staff as to why that evidence was not presented at trial. So this is why I've put it in the defense, the role of defense counsel category for trial is that, you know, you may have a client at trial who has a different lawyer at the Court of Appeal. And at the Court of Appeal in Ontario, this litigant, this accused, wanted to bring forward fresh evidence about, you know, a strategic decision that was made by defense counsel at trial not to call evidence that he thought might help him in his defense. And, you know, we're limited in the instructions that we take, you know, where strategy is not somewhere where we're bound entirely by instructions, but I think it's very smart to listen to your clients for these very reasons, because your strategic decision may not be in line with them. And later on at the Court of Appeal, another lawyer might be really questioning why you took the approach that you did. This fresh evidence motion is not granted by the Ontario Court of Appeal. So this fellow does not have the opportunity to, you know, try to enhance this self-defense claim, even though he, as the accused person at trial, may have wanted to do this in his trial strategy back in the day. So I don't want to be an armchair lawyer on this one, but it just reminds me that, you know, strategic decisions, we really got to think hard and bring in our clients, I think, when we're making those strategic decisions, because you never know, you know, hindsight, right? So the Ontario Court of Appeal does not let in the fresh evidence, but there's a dissent. The dissent would have admitted the fresh evidence, and the dissenting judge at the Ontario Court of Appeal felt that if the fresh evidence, you know, were believed, a jury could acquit, so that it should go back to trial and this fresh evidence should be considered. As an armchair lawyer, I kind of agree with the dissenting judge. But unfortunately, it's very, very, very hard to sometimes win appeals. And the Supreme Court of Canada, heard this case and said, nope, we're not going to hear the fresh evidence. Your second-degree murder is upheld. And it all comes down for this, person in the chair, the person who's facing the charge. All of this litigation comes down to, I kind of wish my lawyer would have done this, followed the strategy that I wanted to. Now, the lawyer may have had very, very good reason not to. But for the accused person, this is clearly something that stuck with him. And as a regret, and so far that he went to the Supreme Court of Canada about it. So yeah, an interesting one. That one just came out and I added it to this presentation a little late. So I haven't had like a big opportunity to do a deep dive on this one. So I think that might be an interesting case to look into further too. So to me, it raised important strategic questions about defense work at the trial level. And then also if you're on the Court of Appeal, at the Court of Appeal level, I'm curious because I haven't, done a deep dive into this. I'm curious if an avenue such as incompetence of counsel were pursued, if it rose to that level. I'm not sure because like I said, again, I added this a little late and I worked from not the full decision. I haven't read that in full. So that's Madani. Next, I've got a few honorable mentions because I just found them interesting. Some of them are interesting because they're just like a little bit, sometimes cases are stranger than novels, like reality is stranger than fiction sometimes. And some of these fall in that category. So first off, Shepherd. This one's not that weird. It's just something good to keep in mind. Shepherd was a historic sexual assault case, and the Supreme Court just sort of simply stated that Friesen applies even with historical offenses. Shepherd wanted his sentence reduced. Was unsuccessful in that. They distinguish this from what we call retrospective punishment. So this is different from, when the legislation changes and the sentencing provisions change over time, which creates a charter issue. So for retrospective punishment, that means that the offender cannot receive a harsher sentence than the maximum penalty set by law at the time that the crime was committed. Friesen, in this case, doesn't defend anything on that front. So they're saying no, contemporary sentencing principles apply even for historical offenses. And that was just simply that for honorable mention. Next one was WW. He was, this fellow, he was in his 50s and he was sending sexually explicit material to someone under 16 for the purposes of facilitating later sexual offense. So it's 171.11B of the criminal code. So this offense targets early steps that can lead to a sexual offense, such as grooming. And the court confirms that the Crown does not need to prove that a sexual offense actually happens later. At the trial, the judge throws the case out because they say, there's no evidence that this is really leading to anything. It just could be like awkward flirtation, right? But the Court of Appeal concluded that they would have, a properly instructed jury in that case would have found him guilty, that it couldn't just be chalked up to flirtatious. And even if it was, that's not what the law is. The law does not require proof that an accused intended to actually commit a sexual offense. They only need to show that the accused intended to make the sexual offense potentially easier or more likely by sending explicit material. So you've got to be really careful if you have a charge like that, not to think that that must lead to something or must be certain to lead to something down the line. It's more of a grooming provision. So that was a good clarification from the Supreme Court. Then the last one, which I thought was wacky, is this DeSutter case. So this appeal is about 2 counts of sexual exploitation involving teenage complainants. And the big issue was whether or not the accused conduct was sexual in nature. And there was a bit of evidence that if it had gone in would have helped the Crown prove that what he was doing was sexual in nature. So what this accused wants these teenage girls to participate in is being sawed in half by a magician. So DeSutter is a magician, and he wants to saw these teenage girls in half. And the Crown was in possession of a USB stick from his home that contained other images and videos of magicians sawing women in half. And those ones were very, the Crown argued, were very clearly showing that there was a sort of a sexual motivation behind this sawing in half. So the trial judge refuses to admit the USB images because of the risk of unfair prejudice greater than their probative value, and they acquit. The Nova Scotia Court of Appeal majority agrees, and they say he should be acquitted. There's a dissent that brings the case to the Supreme Court of Canada, who says that the USB should have been admitted, and then the judge could then have the full context to decide whether or not this proposal sawing these teenage girls in half with a cardboard saw was sexual in nature. The Supreme Court ultimately sets aside the acquittals for sexual exploitation and orders a new trial. I am very curious to see where that ends up, because it certainly does seem borderline to me. But again, we're not aware of totally the nature of the videos that were on the USB stick that might bring this Magicians Act into the category of conduct that would be sexual in nature with these teenage complainants. So interesting case going back to trial in Nova Scotia.
Oh, that's the SEC just saying you gotta do it all over again?
Yeah, sending her back to trial. They'll look at the evidence they'll look at the evidence. So whenever the Supreme Court feels that they don't have enough on record, because remember, they don't hear witnesses. They don't get the benefit of hearing witnesses. They only get to read transcripts of the earlier proceedings and then the documentation that's submitted by the parties. So they're not really in a good position. Neither is the Court of Appeal really in a good position to assess credibility or tone or demeanor of a witness. So that's why at appellate levels, you'll often see people or courts sending things back to trial instead of making a decision outright. Now, if the question if the question at hand is just, usually a question of law, they're more able to do that without having to rehear any witnesses. And that's when you might see a conviction being entered or an acquittal being entered by an appellate level court. But if it has to do it all with weighing of evidence, they'll generally send it back down. So it makes for a very long journey for the accused person, because they can end up, it takes years and years to get to the Supreme Court of Canada. And then all of a sudden you're sent right back to square one. And then Crown attorneys will also make decisions then about whether or not they'll proceed, often based on the feedback that they get from the appellate court. So in this case, it sort of tells me that I would imagine the Nova Scotia court will proceed, because the Supreme Court is of the view that the USB should have been played. So really, it does give the Crown a better possible outcome with this direction from the Supreme Court that not seeing that USB was an error. They actually have a pretty good chance potentially of a conviction with that USB.
The judge is saying, no, it's too prejudicial. And the Supreme Court says, no, look at it. And like,
yeah. And to be honest,
you're gonna need a new judge now.
Yep. And it may also say to the complainant, or sorry, to the accused, that now that the Supreme Court has said that USB will go in, do we go back to trial, or do we acknowledge that that was of a sexual nature and that the Crown could maybe make their case with that USB in? All of it, we can play armchair lawyer, but we'll have to see.
Absolutely.
And I guess that, yeah, it all comes down to what's on the video, right? So that'll be an interesting one, just from it's so novel. It's so novel.
Yeah.
Right? Being sawed in half. Anyway, so those are the cases that I wanted you guys to know about. And thank you for coming to my Supreme Court of Canada year in review. It was a pleasure. And I hope you all have a good Friday afternoon.
Does anybody online have any questions for Hillarie? We have a little bit of time left here.
Who's your favorite Supreme Court justice, Hillarie?
Okay, so here's the thing. I am not that kind of nerd. And I'll tell you a story. I want to see your faces here. One second. I'm going to steal this. Who asked me that? Gary?
Maybe.
Okay. So I am not that kind of nerd. Like, I don't even know what their names all are. You know, like I'm not like I don't, you know how some people follow basketball and stuff like that, and then they follow the Supreme Court of Canada, like they follow basketball and they like know the player names and like what their backgrounds are and what their politics are. I don't know any of that. So when I went, I just liked how they looked. And I really liked the lady with the very nice hair, who I understand, I think a lot of the senior lawyers might know because she used to be
Sheila
married.
Martin?
Yeah, she's got beautiful hair.
Sheila Martin.
Sheila Martin has beautiful hair. I really liked the Irish looking fellow. I thought the way that he thought about things, like his face as he was thinking about things, Roe maybe?
Yeah.
Yeah. I thought the way that he thought, like his face was just so animated and amazing. Yeah, I'm not that kind of nerd. So
I've not been to the Supreme Court, but I do know some members of the Supreme Court came through Winnipeg several years ago when they did the JKJ, when they heard a case here at our courthouse. And then there was who was it? Some retirement, and there was a dinner and some of the Supreme Court members came. And Sheila Martin was at our table.
I think we had just about all of them in Rob's office.
Did you? Yeah.
So we had a student also to make this road trip, and he is that kind of nerd. So I had to keep leaning over and be like, which one is that one? Who is it? Who's that one? What's there? And I'm like, oh, but I'm not that kind of nerd.
It's too much to keep track.
They all had very good questions. I was really impressed by their questioning, and I was really impressed by how the Supreme Court litigants were obviously very used to being able to shift gears, access legal history, like on the fly. I was so impressed by the appellate lawyers on all sides. Like, whew.
Anybody else? Any other questions? Feel free to unmute yourselves or throw a question in the chat. I'm seeing nobody unmuting themselves. Okay, so just so you know, Kevin, I see.
I just wanted to say sorry about that. I thought my mute was on. Somebody came in my
That's
office.
okay. That's okay.
And
Don't worry about
second
it.
of all, thank you very much, Hillarie. I thought you did a great job.
Thanks, team.
Okay, so I am recording this session today, and it will be uploaded to our Lunch and Learn page, as well as the slideshow that Hillary's provided to us.
Yep.
So all of that will be available for review. Just as a matter of housekeeping, so everyone's aware, starting for the next round of Lunch and Learn sessions, there's going to be a Lunch and Learn calendar. I will be sending around an email with all the instructions, how you can all add that calendar to your desktops. So then you can just yourselves check what's coming up when. I will continue to send around reminders with all the links and whatnot for it, but just so you know, that will be coming very shortly. All right, well, having said that, we're going to cut this one off now. And again, if anyone has any follow-up questions, go forward. You can feel free to either reach out to Hillarie directly, you can send them to me and I will reroute them to her. But in any event, I hope everyone has a great rest of your day. Happy Friday, and we'll see you on the next one.
Bye, guys.
Bye.
That's fun.